Good afternoon, everyone, and welcome to the final session of Tillich and Gibbons Annual Employment Law Forum 2020. Today's webinar will provide an overview of employment law and the impact of COVID-19 in Laos. Before we begin, a little housekeeping for the webinar. We gladly welcome your questions and invite you to write them in the comment box on the right-hand side of your screen at any time during the session. As we have a large number of attendees today, all of you have been placed on mute, and our speaker will address questions at the end of the presentation. Should you have any technical issues, you can also type them in this box, and our IT team will be on hand to assist you. With that out of the way, it is now my privilege to introduce our distinguished speaker today, Mr. Dino Santaniello. Dino is the head of Tillich and Gibbons office in Vientiane and has broad experience across several fields of law, including labor and employment, foreign investment, company establishment, and various other corporate, commercial, and intellectual property matters. Based on the strength of his legal expertise and client service, Dino has been recognized as a leading lawyer in Laos by several major legal directories, including Asia Law, Chambers and Partners, IFLR 1000, and the Legal 500. I'm sure you'll agree that there's no better person to speak to you today about this topic. And with that, I'll now hand it over to Dino.
Good afternoon, everybody, and thanks to Derek for the introduction. So I'm very happy to be here with you today. So as Derek mentioned it, my name is Dino Santaniello, and I'm the head of the office of Tillich and Gibbons in Laos for now about 3 years, but I've been living in Laos for more than 4 years and a half already. And today's topic will be about employment law and general overview of employment law, the labor regulatory framework in Laos, and also the impact of COVID-19 related measures to that regulatory framework. About COVID-19, just a little bit of background maybe about what happened in Laos. So at the beginning of the pandemic, around February, March, there was the establishment of a National Task Force Committee to prevent actually the spread of COVID-19, but also to mitigate any economic damages that may be caused by the COVID-19 in Laos. And that committee actually has fulfilled many roles with the government, like advising the government on sanitary measures, but also on measures to mitigate those economic risks. Recently, there was also a regulation issued by the Prime Minister's office in November 26, which says that technically Laos remain under lockdown, even though now businesses have been, almost all of them, if not all, have resumed operation back to normal, but borders remain closed. And about health issues in Laos, so I'm happy to say that Laos has just, to date, has just found 39 cases total recorded by the authorities. No death also as well have been recorded, which is a very good news and which proves that Laos is very safer than other neighboring countries, unfortunately, today. So without further ado, I would like to introduce the topic that we'll be discussing about today. So it will be divided into 7 parts. I will have just about an hour, so sometime my discussion or my explanation may be general, but I'm happy, as mentioned Derek, I'm happy to take any question after during the Q&A session or by email if you think that you don't have time to raise any questions through the Q&A. So the part 1 will be about employment contracts and entertainment, part 2, internal regulation, part 3, National Social Security Fund, part 4, suspension, termination, and severance payment. Part 5, foreign employee work permits and visas. Part 6, dispute resolution. And part 7, hygiene and safety measures. So now on all those topics, actually not every topic have been severely or even slightly impacted by COVID-19. For instance, employment contract, there was not much change to the current regulation, but unfortunately, issues related to termination, severance payment have kept busy HR departments of many organizations in Laos. And also there have been an impact relating to foreign employee and the import of foreign labor during the lockdown, and also indeed hygiene and safety measures, particularly have been impacted by the pandemic of COVID-19 and the need for Laos to issue maybe some specific measures in this regard. So let's start to part one, employment contracts and entertainment. So here, actually, I would say generally Laos divide employment contract into two types. So you have fixed term contract and indefinite term contract. So fixed term contract will be indeed, as the name says, for a limited period of time, while indefinite term contract will be for a period where we cannot foresee to date when the contract will be actually terminated. So with regards to the choice of what type of contract actually an employer may have to opt for, there is no bad answer, there is no right answer, but it really depends on the need that the company has. And if you want, for instance, to have more room to screen or to assess the capability of your employee you're going to hire in your company, then you may want to opt for the fixed term contract. The other good side of the fixed term contract is that it's less cumbersome at the time that you want actually to terminate the contract. You just have to leave the term of the contract lapsed and the contract is terminated. Then at the same time, you have also the choice to opt for indefinite term contract. So here, there will be a lot of implication in terms of whenever you want to terminate that contract, because you may have, and we will see that, to abide by some specific measures regarding to advance notice, for instance, severance payment, and so on. But it will really depend on how you see your potential candidate. So as I said, if you're not sure of the ability of the candidate, so you may want to give that person a try for a year, for instance, and see how capable the person is. And on the other hand, if you feel that you're pretty sure that the candidate is the right one, so you may want to propose an indefinite term contract. And this is very true in Laos because it is pretty difficult to find qualified people. As you may have noticed, if you already have a business over there, qualified people is pretty scarce in Laos. So you may not want to take the risk to actually have that person going for another company. And you may want to secure that person working for you as soon as possible. So in that sense, then the indefinite term contract would be the best option for you. Either case, in any way, there are some rules that will apply to those contracts in any case. And here we can, for instance, we can say that employment contract with a legal entity must be made in writing. So in Laos, there is no way that a legal entity with the employee may be able to just have a verbal employment contract. Also, according to the Lao law, the Lao law applies to all employers and employees working in Laos, which is not maybe true for government officials, which are governed by some other specific measures, specific regulation. And that's about it, actually. So then after that, we will see also as well other employment and entitlements regarding to employment contract. The other thing I would like to say, maybe as compared to other jurisdictions, there is no necessity in Laos to proceed with the registration of an employment contract with the Ministry of Labor in practice, because by law it's mandatory, but the Ministry of Labor and Social Welfare doesn't have yet the system to register Lao employee, for instance. Things differ for foreign employee, foreign labor, because they must be registered with the Ministry of Labor and Social Welfare at the time that you will be seeking for the authorization to import foreign labor. So what about fixed term contract? So there are some rules that actually you must observe whenever you want to opt for a fixed term contract. The first one is that the duration of the contract and the extension thereof cannot exceed 3 years. If the duration or the extension of the fixed term contract exceeds actually the 3 years, then the contract would be requalified as an indefinite term contract. And the other rule, I would say, is that the contract must be renewed within 16 days before the end of the termination of the contract. So here there is a lot of implication actually if your contract is requalified as indefinite term contract. As I said, then rules relating to advance notice must be observed, but also severance payment and so on. So you may want to be careful. So below here on the slides, you may see I rate some instances where a contract may be qualified a fixed term contract, and then where a contract may be qualified as an indefinite term contract. So for instance, if you have a fixed term contract of 2 years, and then you want to renew the employment contract for another year, we are still under a fixed term contract. The same goes for if you have an employment contract with an employee as an employer of 1 year, and then you renew this contract for another 2 years each time. So we are still under a fixed term contract. But on the other hand, if you have an original employment contract for a duration of 2 years, and then you renew exactly the same contract for exactly the same duration, then it will be indefinite term contract. And the same applies if you have a 1 year fixed term contract, and then you renew this contract for 3 other times for the same duration. Here again, the contract will be requalified as a indefinite term contract. So you may want to be careful about this and really keep records on the fixed term contract you have with your employees. Now, relating to the content of employment contract in Laos. So first of all, as maybe compared to other countries, there is no mandatory template to be collected at the Ministry of Labor and Social Welfare. So actually, the draft of the contract may be made by the employee itself. But according to the Lao Labor Law, Article 78, there is some information that must be provided in the employment contract. And here on the screen, you can see that the minimum information that must be covered actually in every employment contract in Laos. So namely, you must have full name, address of the employer and the employee, scope of work, rights and obligations of the employee, salary and method of payment, duration, date of commencement, expiry of the contract, probation time, if any. So here, be careful, because if you don't put the probation time, it could be deemed that there is no probation time according to the employment contract. Welfare and benefit for the employee, working days, rest days, holidays, benefits entitled to the employee at the expiry of the contract, and other matters that may be deemed necessary according to the employee and the employer. What about salary? Is there one in Laos? The response is yes, we have a minimum salary in Laos. So this minimum salary is 1,100,000 Lao Kip, which amounts to about, as of today, $180. And this minimum salary actually is set out by a notification is issued by the Prime Minister's office in April 2018, and previously the minimum salary was of 900,000 Lao Kip, and it could be changed actually from time to time depending on the decision of the Lao authorities. But to date, what we can say is that we don't see any foreseeable change in this regard, and given the economic situation, I would say, of the country, but even worldwide, we do not see any foreseeable change again in the near future. So we don't think that this may change next year or the year after. So next, for the probationary period that actually I did briefly mention. So the Lao Labor Law does provide a probationary period in Laos. So according to the Labor Law, the probationary period is of 30 days for what the Lao Law says unskilled labor, and 60 days for what the Lao Labor Law call for skilled labor. So we will see those two categories, and that the Lao Law are often mentioned, and the Lao Law does separate employee into two categories, skilled and unskilled. So there is no clear definition, but we could say that unskilled labor is labor that we can find working in factories, for instance, using physical force, while for skilled labor, it will be more people having a certain position in a company, but also the authorities may refer to the education of that person, even though in practice, usually they will just refer to the position of a person to be qualified as skilled labor or unskilled labor. So you can see that the probationary period is different according to the category of the employee. And we can see also as well that the probationary period is pretty short. So that's why I was mentioning the fact that fixed-term contract can be a good solution if you're not sure about an employee, because probationary period is short, but also, as you can see on the slide, the probationary period cannot be extended. So as long as the original probationary period is over, then the regular contract will start. There is no way in the law that you could actually you could be authorized to extend the probationary period. And another thing about probationary period in the Lao labor law is that there is actually an advance notice to provide whenever you want to terminate an employment contract under a probationary period. So that advance notice will be of 3 days when we talk about unskilled labor, and it will be of 5 days when we talk about skilled labor. Another thing also to mention is that the salary cannot be lower than 90% of the regular salary under the employment contract. Now, general rules about working hours in Laos and overtime. So the working hours in Laos is limited to 8 hours per day or 48 hours per week. And beyond that working hours, then you will need to have, it will be considered as a working overtime. So you will need to have the approval of the trade union or the majority of the employee or the representative of the employee. And in addition to that, you will need to also submit an advance notice and an explanation to the employee. Also, overtime rates may differ according to the day, but also to the time the employees are actually working. So this is something that the employer may want to be careful about. As you can see, the normal rate for overtime will be 150%, but then that rate may increase depending on the day and the time. So 200% of the normal rate if work at night between from 10 p.m. until 6 a.m., 250% during days off on public holidays, 300% during days off or on public holidays from 4 p.m. to 10 p.m., and then 350% during days off or on public holiday from 10 p.m. to 6 a.m. But there are some limits to overtime actually, and overtime cannot be for more than 3 hours per day or 45 hours per month, except exceptional authorization from the authorities to actually exceed that limit. And also, overtime may not be actually made for more than 4 consecutive days. So here, another topic, very that may be subject to debate in Laos, and we'll explain why. So days off and annual leave. And here we can see that according to the Lao law, you have 1 day per week. But the Lao law also provides some room, because the Lao law say 1 day per week, which could be Sunday or any other day as agreed between the employee and the employer, or 4 days per month. That gives a little bit of room actually for that weekly rest. Then annual leave, 15 days per year, but these annual leave will be increased if the employee is supposed to work under harsh condition or difficult condition, or in a position where the health of the employee is at risk. So here, employees will be entitled to 18 days per week. For the public holidays, and this is where there is some debate sometime in Laos, for those people used to the Lao climate, they may have faced with such issue. So according to the labor law, and there is also a decree on public holidays, which is issued in 2017, and they set 8 days per year. And on top of that, for foreign employees, there are some good things, because foreign employees are actually entitled to take a day off for the national day of their country of origin. So if you're French and you want to take a day off on the 14th of July, you can. And if you're a US citizen, maybe, you can also take a day off on the 4th of July. That's something that the Lao law entitles you to do. So what is sometimes there is some debate, because those public holidays that actually do not include religious or traditional holidays. And for many Lao people, it's something understood that some religious days are actually day off. So this is where this is very important for you in your internal regulation, and we will see that later, to exactly say what are the public holidays for your company if you're an employer. After that, we have also personal leave, which may be a little bit specific to Lao regulation, and I will get back to that just after this slide. Maternity leave, at least 105 days, but 42 days must be taken after giving birth. And Lao does specifically speak about sick leave also as well, and provide 30 days per year full pay. So here for sick leave, the only condition will be to have a medical certificate when the employee gets back to work. So personal leave, according to the Lao law, actually, employees of companies must have not less than 3 days every time some events occurred. So here are the events for which the employee is actually entitled to take not less than 3 days every time it happens. So whenever the employee's father, mother, husband, wife, or children are injured or hospital, but nobody can actually take care of those people. When the employee's father, mother, husband, or wife, or children also pass away, so the employee is entitled to 3 days, not less than 3 days. When the employee gets married, when the employee's wife gives birth or miscarries, and when the employee is affected by a natural disaster. So here again, I would like to insist on not less than 3 days. So you cannot ask, according to the Lao law, we cannot ask the employee to get back to work before that time if the employee has taken a personal leave. Also, the Lao labor law does not seek to limit the number of days that can be taken according to personal leave. So maybe here again, that's something you may want to try to frame under the internal regulation, asking employee very specific document in the event that they must take personal leave, in order maybe to limit people that may abuse it, but it's not really much a problem in many of the companies we've been working with. So after that, I would like to mention, because I think that's natural prolongation of what we just talked about, internal regulation in Laos. So that will be brief, but first of all, I would like to say that internal regulation is mandatory, and it's kind of a law between the employer and the employee. And in the internal regulation, the employer will be able maybe to add some specific details, clarification about benefits that all the employees are entitled to, but also about disciplinary measures. And that's very important because the Lao labor law is not very specific in this regard. So you may want to actually frame disciplinary measure in your company as an employer if you want to have something clear, and you cannot maybe rely only on the Lao labor law. So this is where internal regulation will be very, very important. So actually, there is a mandatory template to be collected at the Ministry of Labor and Social Welfare. And there is an approval process. I would say there is an approval process, 2 steps approval process. First of all, the internal approval process. So the internal regulation must be approved by the trade union or the representative of the employee or the majority of the employees. And also, the internal regulation must be approved by the Ministry of Labor and Social Welfare. And in practice, what is the best thing to do is that you indeed collect the template, you fill in the template according to what you believe would be your internal regulation. And after this, you submit your first draft to the authorities. The authorities will actually be screening your internal regulation, and most of the time they will have some comments. It could be substantive comments or very small comments, but we do recommend that before you execute actually the internal regulation, you have the authorities screening it, and then once the authorities say to you, that's okay, this is what we recommend to be amended, and after that I will be fine, then at this time you can actually amend your internal regulation. have it executed by, as I said, trade union, majority of the employees or representative of the employees, but also the director of the company. And then you can send it to the Ministry of Labor. For comments from the ministry, it may take about a week or two. It really depends on the availability of the officer. That's the time frame we are usually observed. Are there any other requirements? Yes, language must be in Lao. The authorities will not take a look at internal regulations which are not in Lao language, but at the same time, if an employer has any foreign employee working under its company, then there is a requirement to have those internal regulations in a foreign language. Most of the time, the authorities will be tolerant that we will just limit to English language, which means that if you have a Japanese, a Chinese, or I don't know, a British working in your company, then you may not need to actually translate the internal regulation in all those languages. And for the content, so indeed there is a template as we just mentioned it, but there is also some, I would say, overview of the content provided under the Lao labor law. So here again, we have content which must be provided in the internal regulation, working hours, address, and description of the activity of the company, breaks, rest day, leaves, measures for health and safety concerns, which is pretty important, method for dispute resolution and disciplinary measures, and that's where I think it's very necessary for you to give some attention and to see what should be drafted and how those dispute resolution and disciplinary measures must be framed, but also benefit and mandatory rules for the employees. So that's basically the content of internal regulation in Laos. So now, what are the sanctions? And here, actually, those sanctions are something you can see for one who is familiar with the Lao regulatory framework. That's kind of sanction we usually see: education, warning, fine, and litigation. So it goes from light measures to stronger measures. So education here, usually the officer will summon the employer to come and to explain the importance of internal regulation, but also explain the process on how to actually have the internal regulation approved. Warning is when the officer from the Ministry of Labor and Social Welfare realizes that you didn't yet have your internal regulation approved despite the education measures. So here there will be an official formal warning issued to the employer. Fine, as you can see, they are pretty low. Here we'll talk about 1 million KIP for companies of less than 100 employees and 2 million KIP for company with 100 employees or more. So it's for the first, for 1 million, sorry. Lao KIP, it's a little bit more than $100. And for 2,000 Lao KIP, it will be a little bit more than $200. But after that, actually, there is a wide range, and sometimes it's pretty much a gray area on what exact measures the Lao authorities may be able to take against an employer. So according to actually a decree on the implementation and the operation of work inspection officer, which was issued in 2016, the next step would be actually to go to litigation, which means that the officer from the Ministry of Labor and Social Welfare can actually pass the dossier onto a judge of the Lao People's Court. But it's pretty, there is no clear sanction after the fine. So we believe that there is a broad range of power that the authority may want to apply for a very specific case. So most likely they will consider the situation on a case-by-case basis. National Social Security Fund. So this is an important topic, and what we've seen actually is that there have been a loose application of the mandatory contribution to the National Social Security Fund during the past year. So the authorities really emphasized on the obligation for the employer, but also the employees to contribute to that National Social Security Fund, which provide actually health care at state hospital to employees, for instance. And we can say that today there is a more inspection from the Ministry of Labor and Social Welfare to be sure that all employers actually abide by this obligation. So here Sometimes we heard that some companies, whenever we made some audits in some companies, the employer may say that, but they have a very, the size of the company is not big, or they just have less than 10 employees, so they are not supposed to be registered with the National Social Security Fund system, which is not true, because according to the Lao law and the Lao labor law or the law on social security, it's very clear, as you can see on the slides, that all employers, but also employees, must contribute during their working period with the National Social Security Fund. So the registration actually is pretty easy. As an employer, not much document is required. Usually proof of incorporation, tax certificate will be necessary, article of association, and it takes about 2 working days to actually have a certificate issued by the authorities that actually certify that the employee is registered under the National Social Security Fund system. For employees, there is an obligation to be registered and to contribute also to the National Social Security Fund within 30 days of the signing of the employment contract. And here it takes about 30 days to be registered and to have, usually there will be not usually, all the time there will be a National Social Security Fund, a card issued by the relevant authorities, which prove that actually the employee is correctly registered under the National Social Security Fund. And the contribution must be paid by the 15th of each month. So when we say that, what is the contribution actually? So the contribution is of 6% of the employee's salary for the employer and 5.5% of the employee's salary for the employee. And it's good to know also as well to mention that contribution is capped at 4,500,000 Lao kip, which amounts about $485 as of today. So warning, again, you can see that's part of the sanction that can be issued by the authorities. Here, there will be usually when the authorities, the inspection work officer, they realize that one is not correctly registered with the National Social Security Fund. There will be minutes recorded, drafted and recorded by the authorities. And the authorities, they will give also a 90 days period to the employer to actually adjust and go and register correctly with the National Social Security Fund in Laos. And after that, the next step, still under the decree on, it's actually under the law on Social Security. The next step would be actually to have a fine issued by the authorities to the employer. And the fine will amount to the same amount that the employee should have contributed into the National Social Security Fund. So for the next step, suspension, termination, and severance payment. And unfortunately, as I've said, it has kept busy lots of HR department in Laos. We've seen the impact directly of the COVID-19 in Laos because lots of termination recently. And it's still going, unfortunately, even though we realize that now things are getting better. So first of all, I would like also to say that the COVID-19 period made us realize maybe 2 things. First thing is just a comment about the Lao labor law. The Lao labor law did not anticipate such a pandemic, and we can say that it does not provide maybe lots of flexibility to the employer to use the Lao labor law in order to maybe try to mitigate the economic loss due to such a pandemic, but who could have maybe anticipated that? So that's the first comment. The second comment, on the other hand, had us to realize that negotiation between employer and employees are of utmost importance in Laos. And this is where most of the time a good solution was found between employee and employers in order to try to mitigate as much as possible through negotiation how employees may leave the company or maybe suspend the contract sometimes. And talking about suspension of employment contracts, so here on the slides, it's a brief overview of the possibility to suspend a contract, an employment contract under Laos labor law. So the possibility are pretty limited though, because first of all, it will concern for employers which have to undertake the national service. So here, definitely the employer can suspend the contract and not have to pay salary benefit, although this cannot exceed 1 year. And at the time when the employee is done with the national service, then the employer will have to actually take back the employee. If the employer does not want to take back the employee, or if it actually provide another position which is not similar to the position before the employee left for national service, then it could be deemed that the employment contract is terminated and severance payment will have to be paid. And also, it could be that the employer suspend the contract if the employee is detained for some decision from the authorities somewhere in Laos. Here again, there could be a suspension of the contract for a year, and no salary or benefit could be paid. And one more thing also as well, if the employee does not wish to return or does not return on time, then the employer can definitely also terminate the contract without compensation, which means actually without paying any severance payment. The other possibility, which is more suspension of activities of the business, we are business impacted by COVID-19. So here, according to the Laos labor law, there is a possibility for business activity to be suspended, first by order of the Laos authorities. It could be a court decision, for instance, but also it could be via a decision of the employer alone to suspend the activity temporarily. So this could be a good solution actually regarding the COVID-19 situation. But at the same time, what we can realize is that during that time of the suspension of the activity, the employer must pay at least not less than 50% of the salary of the employee. So it is possible to actually suspend the activity, but not possible to suspend the employment contract. So there will be less obligation maybe from the employer to pay a full salary, but not less than 50% of the salary must be paid anyway. And if the salary is already at the minimum, the minimum salary, then the employer must pay the full salary here. And the other, and I just briefly mentioned, the other way to actually be able to suspend the contract, even though one may be careful, but is definitely through mutual agreement, where the employee and the employer can agree together that for the time being, it must be better to actually suspend the contract and resume the contract at a later time when things would get better. But it's very difficult at the same time also to frame exactly for how long can we suspend the contract. It's a gray area in the Laos law. So as long as there is an agreement between the employee and the employee, it should be fine, but still one may remain cautious on the period where the suspension may take effect. And by law, I would like just to add that there is no suspension possible for force majeure. So COVID-19 is not supposed to be a force majeure according to the Laos labor law, because there is no such definition in the Laos labor law. So we saw a lot of companies raising force majeure, but without maybe knowing the content exactly of the Laos labor law. For termination then, I will try to be brief because we may run a little bit out of time. So termination, I would say there is 3 ways to actually terminate the contract, and I deliberately disregard the fact that there could be also a termination based on mutual separation agreement. So here is when the employee and the employer agree together to terminate the contract, and also on the package for the termination, severance payment, and all the benefits. But other than that, we can say that there is 3 ways that the contract can be terminated. Is a termination by the employees, a termination by the employers, but based on no fault of the employees, and then the termination by the employers with the fault of the employees. So termination by employees, according to the Laos labor law, it involves health issue, no resolution of issue or concern raised by the employee, and the employer didn't take any action in order to try to resolve those issues. Also relocation of an office, can be part of a termination by the employee. But here, it must be also understood and it must be also proved that the employee would not be able to actually fulfill his duty under the employment contract because of the relocation. So let's say a company just relocate 1 kilometer away or even less, 500 meters away. It's not a good reason for an employee to actually ask to terminate the contract based on relocation. And lastly, there is also because of harassment, an employee can actually terminate the contract. We'll see afterwards what is the consequence of that. For termination by employers based on no fault of the employee. So here we can mention first lack of skills and health issues. So for those two issues, lack of skill and health issue, actually the employee will have first to try to have the employee working in a position that may fit better. And for health issue also, of course, the employee will have to try to put the employee in a position that may fit better for the health condition of the employee, but a medical certificate will also have to be issued. And there is also the possibility for employers to terminate the contract based on no fault of the employees for business reasons. So this is more or less what may be mass layoff under Laos law, even though it's not explained like this. But I will get back to that right after this slide. And then there is also termination by employers with fault of the employees. So here, this is where employee deliberately cause damages to the company. The law does not say if it's financial or physical damages, so both could be actually interpreted as being deliberately damages caused by the employee, even though financial damage may be harder to prove to the law authorities. Then the violation of internal regulation after being warned at least one time can be a cause for the employer to terminate the contract based on the fault of the employee. The negligence of the employee of his duties for 4 consecutive days, when an employee is actually sentenced to imprisonment for offense to have deliberately caused against the employer, and also violation of the rights of the employee. For instance, an employee is accused of harassing other employees in the company. That could be also a reason for terminating the contract for fault of the employees. And, which is again very important, in the internal regulation of the company, it is possible to set up other reason for terminating the employment contract of an employee based on fault. So this list provided by the law that you can see from deliberately causing damages to violating the rights of other employees is not an exhaustive list. So notice and severance payment. So here, when there is a termination by employees or by employees with no fault of the employees, there is a advance notice that must be provided. Here again, we will divide it according to the category of the labor we talk about. So for unskilled labor, it's a 30 days advance notice. And for skilled labor, it's 45-day advance notice. Here for both for both scenarios, severance payment and termination package must be provided to the employee. On the other hand, when the termination is due to a fault of the employee, there is an immediate termination. No severance payment is actually to be paid. And of course, the only obligation here from the employer is outstanding salary that must be paid in full to the employee at the time the employee is leaving the company. Just to say quickly about fixed-term contract. So fixed-term contract is governed a little bit differently, but just briefly, fixed-term contract can be terminated upon the agreement of both parties anytime, and maybe also terminated when one or the other party breached the contract. If the breach comes from the employer, then the employer will be obligated to pay for the outstanding amount of salary as provided in the fixed-term contract. So here is the termination for business reason I just mentioned before. So here it's the law says for business reasons, or whenever a company or an employer would like to reduce the number of the workforce in order to render the organization more efficient, then there is a possibility to terminate employment contracts based on business reason. So here is the steps that would be usually necessary for an employer to be able to actually terminate the employment contract under that reason. So first of all, there will be a meeting necessary, and the meeting must involve either the trade union or the employees' representatives or the majority of the employees. And that meeting will have to be recorded under minutes of the meeting. And that meeting will be about informing the plan to actually terminate employment contracts, but also the package that will be distributed, provided to the employee who will be terminated. At this stage, it is not necessary to actually name the employee. So it's not yet at the meeting that you will need to name the employee that will be terminated. The second step will be to actually notify the labor administration authority. And here we talk about notification. So you don't have to ask for an approval, but it's a notification from the authorities. Nonetheless, usually the labor administration authority will ask also that you wait for the acknowledgement before delivering the advance notice to the employee that will be terminated. And whenever you send the notification to the labor administration authority, the minutes of the meeting will also be required from the labor administration authorities. Then, once you receive the acknowledgement, once the employer receives the acknowledgement from the labor administration authority, then the employer can actually write and submit the advance notice. So depending, again, on the category of labor, regarding the termination of the employment contract, also explain the reason thereof, and also provide the details of the termination package that will be provided to the employee. And here, actually, the first, last step is a very common step, is just employment certificate, wherein the employer must talk about the position that was actually where the employee used to work in the company and the time period. So here, argument against termination, 2, I would say, and justified termination. So here the employee can argue actually that the termination of its employment contract is an unjustified termination. So here could be raised that the employment is actually terminated without sufficient reason. Let's say an employer wants to terminate the contract based on lack of skills of the employee, but the employee cannot prove the lack of skills of the employee. Then also here, unjustified termination for abuse of power. It's when actually the employer does not provide the capability to the employee to fulfill his duty, and at the end of it, the employee will resign. Here again, the employee can contest his resignation and say that it was actually an unjustified termination. We will see later the impact of it. And also the employer violates the employment contract after being protested. And here it will be more or less like we've seen already, when the employee actually raised issues and concern in the company, but no action has been taken by the employer in this regard. And there is another category of actually people that cannot be terminated easily, I would say. So here is the list of the employees that are deemed to be protected and where the labor administration authorities prior approval is required, otherwise not possible. So the sanction, here I list all the sanctions. For unjustified termination, severance payment will be then increased from 10% to 15%, as you can see. Also, employee can request to be actually reinstated in the company, but in practice it doesn't happen often. And for unauthorized termination, here again, employee can actually request to be reinstated, but if the employee does not wish to be reinstated, then termination package along with severance payment of 10% here will have to be provided by the employer to the employee. So here is the certificate employment certificate I was mentioning, but nothing fancy, just a little bit of information that must be delivered that certificate must be delivered to the employee within 7 days after the termination of the contract. So for an employee and work permit and visa, I will try to be brief on that one, given the time. So first, requirements. All foreigners cannot actually work in Laos. There are some requirements to fulfill, but it's pretty much okay as compared to other jurisdictions where it could be very difficult for foreign labor to work. So here, basic requirements: be over 10 years old, possess the relevant skills for the required work, have no criminal record, receive sponsorship from the companies or the individual that is to hire this person, and possess the relevant work permits and approval. So for foreign employees, employment contract will be actually limited to a 12-month period, and each year we will have to renew that employment contract, but also all the approval that comes with the employment contract. And according to the Lao labor law, the foreign employees are fine to work in Laos up to 5 years, and after that there may be some special authorization to actually be able to pursue working in Laos. So here again, I think that the labor authorities in Laos are pretty much flexible on that, because they know the scarce qualified employees, Lao employees available in Laos. But after 5 years, either the Lao authorities, they refuse to actually extend the contract or extend the approval permits to work in Laos, and or they accept it. If they refuse, then the employee cannot stay in Laos with the working permit and under the employment contract. So there is a quota, 15%. When we talk about unskilled worker, 15% of the total number of Lao employees, while for skilled worker it will be 25% of the total of Lao employees. So here are the actually permits and approval which are required under Lao law. So there will be a business visa, work permit, and stay permit. So before anyway importing a foreign labor, there will be a quota approval that will be need to be requested from the Department of Labor and Social Welfare in Laos before you can actually start the process to obtain a business visa, a work permit, and a stay permit. But again, the whole process may not take more than 1 month, and it's pretty straightforward, and it's not very cumbersome as it could be in some countries. So as I said, quota approval for foreign employees, the quota can be exceeded, and it happens quite often actually. But as long as you have the work permit and the stay permit delivered by the authorities after your request, then everything is fine. And here it's just maybe a process, because it was very difficult, at least until July 31, to import foreign labor in Laos. And here this is a process to actually request a business visa to come into Laos, where afterwards you may be able to proceed with the request of work permit and stay permit. So this is actually the process to be followed in Laos for the time being whenever someone wants to import labor, foreign labor. So I will not linger more on that, and you have here all the details. If you want more details, just feel free to ask it to me. So dispute resolution, there is, according to the Lao labor law, there is 4 ways to settle a dispute: compromise, basically negotiation; administrative resolution, which is very common, not just for labor issues actually in Laos, is where you file a complaint with the authorities and you ask for the help of the authorities to resolve an issue; resolution by the Committee for Labor Dispute Resolution; and Lao People's Court. Type of dispute, 2 types. There will be a breach of regulation, which means breach of law, internal regulation, employment contract, either by the employee or the employer, and also dispute relating to benefit. Here we'll be talking about claim for better maybe environment of work, concerning the working hours, salary, overtime, and so on. So the compromise, as we talk, actually is used to solve issues relating to breach of regulation and benefits. So this is partly framed under the Decree on Labor Dispute Resolution, which was enacted quite recently in 2019. And the good thing is that that compromise, it's a framework that is in a written form in that decree, and it can involve also a third party. So basically, you can have a lawyer assisting to that. And then the results of the consultation between the parties must be registered and signed by the parties. This also can be used for negotiation of collective agreement. And as I mentioned before, internal regulation can provide more details concerning the resolution by way of compromise. By the decree, there is a time frame wherein those negotiations must lead to some results. So 15 days for individual dispute and 30 days for collective dispute. Thereafter, we have administrative resolution, which is actually a good thing if one employer and employee wants to have maybe a mediator in order to solve the issue they are actually facing. And here, there is different levels of mediation, and there are some requirements where, in order to be able to trigger the level at the district level, province level, and central level. But every time things must be made in order. For instance, if you're a company with not more than 10 employees, you must start first to ask for administrative resolution method of solving your labor issue with the district level first. And then if it does not succeed, you may go to the province and central level. At the end of it, if at the central level things are not yet solved or one party is not satisfied, then the Lao People's Court can be actually, the dossier can be actually passed on to the Lao People's Court. Time frame between each step is still 15 days. So here, the Committee of Labor Dispute Resolution is a tripartite committee which involves employer, employee, organization, and also the authorities. Here there are two levels, province level and central level. Again, this is just relating to benefits. So if we are talking about a breach of regulation, then this Committee of Labor Dispute Resolution will not be capable of solving or ruling on such a matter. Finally, the courts will be the last recourse that any party may have in order to solve a dispute. So here it's a brief overview of dispute resolution according to each type of dispute. Again, sorry if I'm a little bit brief, but do feel free to ask me questions afterwards. Part 7, last part of our presentation, is about hygiene and safety measures. I'm sorry for the typo. So there is a lot of ongoing compliance, and those are actually set out under the labor law, but also the decree on labor safety and health, number 220, which was issued in 2019. And here, there is a lot of obligation from the employers to observe. So as we put it in the slides, employers must ensure good environment working condition. Hygiene and safety risk assessment may be made at least once per year. So here, the Lao labor law also provide that it can be made by either the employer, the authorities, or even hire a specialized company to do so. There must be trainings on basic health and safety concerns, supply the necessary gear and equipment. All workplace must also have at least one first aid kit. And for some other places where we believe the risks are maybe higher than the normal, then there may be also the requirements to have very specific equipment to cope with any issue that may be raised due to the very specific environment of the company. And then, as you can see, employees with 50 or more employees in suburban or remote area must have a doctor also available on the site. And employee with less than 50 employees must have a first aid kit, as I already mentioned, but also a first aid employee that would usually have to undergo the necessary training to be called the first aid employee. And there will be yearly medical checkup at the expense of the and supported by the employers. that medical checkups could be twice a year if the person is supposed to work in under an environment that is supposed to be hard or specifically dangerous. So here about some measures about the employment of the safety and health staff. And so according to the decree I just mentioned on health and safety measures, which was issued in 2019, there are some rights actually provided to employees who can refuse to work. So this is very important because the employee can refuse to work if they deem that the place or the working area is dangerous for them. And here are some of the COVID-19 measures that have been actually implemented by and asked by the National Task Force of the COVID relating to the COVID-19 committee, where there are a number of conditions that must be observed by the employers, but also to implement 5 measures. So basically, when this instruction was issued, all companies at that time were asked to have the committee to come and inspect the working area, which was the case, for instance, for Tiliki and Gibbons. We had a committee coming to our office, inspect, and at the end of it, we have a minute of the meeting saying that your company, the premises of the working area actually do observe and respect all those measures and conditions. But for now, I think the authorities, they focus mainly on factories. So these will concern mainly factories, even though according to the drafting of the regulation, all working places must actually abide by those measures. So here again, I'll leave that to you on the slides. It's pretty self-explanatory. So if you need any more information on this, please do feel free to reach out to me again. So that concludes actually the presentation about Laos labor law and the COVID-19 measures. I'm happy to take any question if you have any, and do feel free to do so, please.
Well, thanks very much for the presentation, Dino. As Dino had mentioned, we'll now transition to the Q&A session. As a reminder, we invite you to continue submitting questions by typing them into the comment box on the right-hand side of your screen. Dino will respond to as many questions as possible within the remaining time. And with that, I'll pass it back over to Dino to start the Q&A session.
Okay. So there is one question relating to severance payment. So can severance payment actually be capped? According to the Laos law, no. So it's not possible to actually agree between an employer and employee to cap severance payment. And this has been also confirmed to us by the authorities, because whenever the law is silent, you want to have also confirmation of the authorities of the interpretation of the law. So during previous matters we have actually handled, this is something that the officer told us and confirmed that is not possible by law under the law regulation or even under the interpretation of the authority to actually be able to cap severance payment. Yes, so there is also a question about reporting requirements. Are there any reporting requirements? Yes, by law there is one requirement actually but it addressed more to factories and those kind of premises, where every 3 months the employee must report to the Lao authorities, Lao administration authorities, about risk assessment actually, but also other issues that may be raised, such as how many employees, and to update the authorities every 3 months about it. So it could be how many employees have left the company in the meantime, how many foreign labor have come into the company, left the company, a little bit about risk assessment also as well, and those kind of issues. But to be honest, this is something that even the Labor Administration Authority may not require to all enterprises observe. But This is in the law, so we strongly encourage you to do so. If you want to have more information on that, I'm happy to provide it to you afterwards. But most likely, the officer of the Labor Administration Authority will be very strict regarding factories in this regard and those reporting requirements. Another question about how the authorities are actually coping with the COVID-19 situation. So it's a very broad subject here. I would say that it was very difficult for Laos because maybe Laos has a very thin margin of maneuver in this respect. It's not like Laos cannot just provide lots of subsidies like could be the case like we see in the US or in Europe. So I think it was very difficult for Laos to do so. There were some regulation in order to ease repayment of loan, for instance, where the Bank of Laos has strongly encouraged commercial banks, even though it was not something, it was not coercive measures, but commercial banks, was very encouraged to actually provide delayed deadline to reimburse loans contracted by Lao individual or Lao legal entities, which are facing some specific, very maybe difficult situation due to the COVID-19. They were also made available by the Bank of Laos for commercial bank to provide loan to SMEs in order to be able to cope with the COVID situation. There were also some tax exemption, but on a very limited category of salary through a restriction issued by the Ministry of Finance. But according to labor issues specifically, I think it was more or less given to freedom of contract and negotiation between the parties. So this is how the officer actually worked some time maybe providing practical advice on how to negotiate and with the employer in order to terminate employment contract in the most best manner. So no other questions. I think I was very happy to be able to introduce you to the Lao Labor Regulatory Framework. As I said, if you have any further question, I'm very happy to take even a call if you want, if you think to talk is better. Otherwise, you can send me an email anytime, and I would be actually very happy to be able to provide you with more clarification if at all necessary. Thank you very much, everybody.
Thank you, Dino, for the great presentation today, and thanks to all of our attendees today as well. Later, the firm's marketing team will circulate a feedback form and the PowerPoint slides from today's session. We would appreciate your kind cooperation in completing the feedback form so we can continue to develop our webinar offerings. Should you have any remaining questions, you can feel free to contact Dino directly by using the contact details shown on the screen currently. Thanks again and have a great afternoon.